Hello, everyone. I think it's the right time to get started. My name is Matej Albal. I'm a professor of European law here at the New University in Ljubljana, and I'm also a chair, a Jean Monnet chair of dedicated to pluralism in the European Union. Uh, Welcome back in the year 2023. It's our first edition of the New Year's European Academic Forum, but actually this is already the fifth European Academic Forum in a row. And this time around, we will explore the question, is there a plurality of rules of laws in the European Union? Um, to some, this question might be a surprising one. To others, it might be too provocative. For others, again, it might be even a startling one. But I thought, as a chairholder of a Jean Monnet chair dedicating to pluralism in the European Union, to also engage with the argument of certain member states in the European Union that to some extent there is no rule of law crisis in the European Union, simply for a reason that the rule of law as such, as a concept, is too indeterminate that we could be actually speaking of a European standard of the rule of law as a benchmark against which the performance of the member states can be measured. Uh, Before going into details of our of today's debate, in which I will be joining four excellent speakers, let me say a word or two about this Jean Monnet, about the Jean Monnet chair. So the Jean Monnet chair was awarded to the new university by the European Commission, and its main object and purpose is to reverse the ethos of the declining pluralism in the European Union. So pluralism stands for plurality, meaning doing different things differently in the European Union, for approaching problems from different perspectives. But at the same time, pluralism is not just about plurality, but it is also about the connecting plurality, meaning connecting different member states into a common whole whose functioning has to be coherent in order to ensure the viability of the common whole. And when we speak about the rule of law as one of the most fundamental values of the European Union, it is, of course, the question here whether we can also have diverging, contesting views about the meaning of the rule of law in order to ensure subsequently this coherent and viable functioning of the European Union. The Jean Monnet Chair project is otherwise divided into three pillars. One is a teaching pillar that takes place within a variety of courses delivered to our students here at the new university. Another pillar is the research pillar, and this European Academic Forum today takes part in the so-called civil society pillar. The idea of the civil society pillar is to present the academic ideas in a little bit less academic terms in order to reach the wider audience, to allow an in-depth understanding of the problems in the European Union to the wider audience. And that is why we tend to invite different speakers from different corners of Europe, indeed from different corners of the world, and also from different professional backgrounds. As already indicated, today, the question, is there a plurality of rules of laws in the European Union? I will discuss this question with four excellent speakers. And let me continue by introducing each of them to you very briefly, because if I went in great details, I would use the entire event just to go through the CVs of these excellent speakers, because they have done already so many interesting things despite their relatively short academic or professional careers. So first of all, I would like to welcome among us Professor Dr. Antonia Baraja. She comes from the University of Milan in Italy. Antonia is one of the most prolific scholars in the field of comparative constitutional law. Her research interests have included the role of courts, economic and financial crisis, socio-economic rights, fiscal federalism considered in a comparative perspective, and she has so far authored 3 books and several publications in Italian and English on the effects of the financial crisis, on national constitutional systems, and on the European Union, on the economic conditionality, on fundamental rights in comparative perspective, and on the dialogue among courts. Just when chatting to Antonia right before this session today, she let me know that she's just finished her book, precisely touching almost directly on the topic that we will be addressing today. So, Antonia, I'm really happy to have you with us. The next speaker is Katja Triller-Vertovec. Those of you who are coming from the new university know her well because she's our distinguished colleague, an assistant professor, but more than academically active, she was in the past active in various sectors of the Slovenian state. She was a senior judicial advisor at the Supreme Court. For many years, she was an advisor to the Constitutional Court of the Republic of Slovenia. She also worked as a secretary in the legislative and legal services of the National Assembly. She was an acting director of the Government Legislative Service, and during the former government, she was a state secretary in the cabinet of the Prime Minister, and now she works in a private sector as an attorney. Katja otherwise teaches a variety of public law courses at the new university, but today we invited her in order to especially to present that she would present her experiences from her previous practice in the organs of the Slovenian state, uniquely balancing and combining academia and professional services in the Slovenian governmental and judicial chambers. The next speaker, we have another Katja, and this is Dr. Katja Reec-Longar. Katja Reec-Longar, she is a professional official working for the Slovenian government at the Ministry of Justice of the Republic of Slovenia as a director of the Office for International Cooperation and International Legal Assistance. Katja obtained her degree from the University of Ljubljana. After having passed the bar exam, she also studied at Cambridge University and obtained a PhD at the University of Maribor. She's a practitioner, as I said, as a director of the Office for International Cooperation and International Legal Assistance, and has long, for a very long time, hand in hand with the European institutions, especially with the European Commission. So she's a connoisseur of the practical side of the problems related to the rule of law in Slovenia, but also in the broader framework of the functioning of the European Union. She also argued cases before the Court of Justice of the European Union as an agent for Slovenia. So also, Katja, it's great to have you with us. And last but certainly not least, our fourth speaker is Armen Mazmanyan. Armen Mazmanyan, he's my colleague from the European University Institute of Florence, where he defended his PhD in 2009, after having obtained an LLM from the University of Illinois, and after graduating from the Yerevan State University in Armenia. Armen currently works as a professor at the American University of Armenia. He has held various visiting positions in a number of European countries. He has acted as a consultant, and he has also been active in the field of civil society, advising actors in the private and public sphere. His publications include, he has worked on the communist and post-communist studies. He has delved deeply in the problems and questions of failing constitutionalism, and has, like Antonia, shared interests in the role of constitutional courts in multi-level governance across a comparative perspective. So, as you can see, we have a really great panel today with us. We also have some individuals in the audience. I would also, of course, like to extend my greeting to our audience. And already at this stage, I would like to invite our audience that as you are following this debate, as the debate will be unfolding, you are very, very welcome to raise questions in our chat room. And as those will find themselves there, I will pick them up and direct them at our speakers respectively. Okay, so having now eventually sketched the organizational side of our debate, let me start by going into the substance. And I would really like to begin by provoking you, by provoking you by raising this question, which is in the title of our call, namely, is there a plurality of rules of laws out there in the European Union? And if we bought in that argument, like to a certain extent the Polish government has made it, and to some extent, and even earlier, the Hungarian government has made it, and if we bought into the argument of indeterminacy of the rule of law, from which it follows that if the rule of law is so indeterminate, each of us, each member state can have its take on it, which means that it also can take from it whatever that member state wants. And in that sense, there might be no crisis of the rule of law in the European Union, just different perspectives. So, Antonia, if I start with you, what do you make of that argument?
Thank you very much, Mattei, also for this invitation and the generous presentation. So, straight to the point, I think it's true that there are several definitions of the rule of law, because the concept of the rule of law depends also on the constitutional culture, on the history, and even the theoretical attempt to define an abstract concept of the rule of law failed. We can talk about thin concept of the rule of law or thick concept of the rule of law, substantive concepts or procedural ones. And also, if we look at the Western legal tradition, we see different definition of the rule of law, the Rechtsstaat, the État de droit, Stato di diritto in the Italian legal scholarship, and the rule of law, of course. So there is a point in claiming that the concept of the rule of law may have a specific, particular declination in each constitutional culture. But what I think we can say vis-a-vis this argument against the European rule of law is that what the European Union is saying is that there is a core there are core principles that can define a concept, a shared concept of the rule of law, to which the member states, in the very same moment that they enter, they join the European Union, agree. upon which. So, and this is clear also in the decisions with regard to the regulation after the annulment action brought by Hungary and Poland. In the Court of Justice said that the regulation does not provide an exhaustive definition of the concept of the rule of law, which seems to be impossible, but simply set out a number of rule of law principles that are relevant for the application of the regulation. Principle that the member state must be committed to since they are part to the European Union project. So the argument per se may have this sense with regard to the specificity of the rule of law concept, but if we put this argument within the broader context of the European Union, this cannot be sustained because Hungary and Poland decided to be member of a common project.
Thank you very much, Antonia, for outlining the various dimensions of the definition of the different traditions, and of already bringing up also the very important, the landmark decision of the Court of Justice of the European Union regarding the shared content and the core issues, the core understanding of the rule of law. Katja Reetz-Lonkar, from the you're today speaking, of course, in your personal capacity, but at the same time, you're also the director of the Office for International Cooperation. When you engage in your capacity with your colleagues at the European Commission, or on the horizontal level, do you also encounter these difficulties related to the definition of the rule of law, or is this just an academic problem, and those who are trying to avoid the responsibility from the breaches of the rule of law, they might be just making this their argument in a bad faith? So how do you see this from the governmental perspective?
Yes, Matej, thank you so much, and thank you for inviting me. But I would I absolutely agree with my previous speaker, because yes, of course, there are many definitions of the rule of law. When I was Googling and preparing for this panel, I noticed, yes, there are different perspectives, like maybe some focus on legal predictability in some states, and then protection of individual rights and freedoms, and government accountability in some other parts of the world. But from my perspective as a government official, we actually know what the rule of law in European Union is, because it's quite well sort of sketched in the monitoring mechanisms, and we get this questionnaire every year, and it's very well structured. So it's about courts' independence, and of course certain aspects of courts' independence, different questions in this respect: media freedom, separation of powers, protection of human rights, anti-corruption framework. However, having said that, when, of course, I have to advocate for my country, because basically it's not in our interest to sell ourselves as somebody who's breaching the rule of law, because there are consequences. But having said that, of course, what my experience is that Commission a lot focuses on perceptions, and it's not only in the rule of law, but many times when speaking with the Commission or other EU institutions, everything is based on perceptions. If a member state is perceived as, I don't know, corrupt, backward, I don't know, new member states, I would argue that we are not considered in this, like, equally compared to older member states. And this will, I don't think anyone would admit that when you talk to them formally, but off the record, you would hear things like that from the commission officials. And of course, the rule of law is also, and maybe we could tackle that later on, is a very fluid concept anyway, because when during the crisis, you know, the perception of the rule of law changes. My field of expertise is confiscation of assets, and what we are considering doing at the moment at the European level would be absolutely considered as a breach of the rule of law like 10 years ago. But this is maybe a debate for later. So thank you.
Absolutely, thank you. I'll certainly will get back to you because I'm really curious now about your last remark. But I will pick up on something else that you said, and that is that, and this echoes also a little bit with Antonia, that the rule of law is always a little bit in the eye of the beholder already when we approach it conceptually, right? When we try to define it, but it gets even messier, even more difficult when we try to apply that particular, even if shared definition into practice in order to determine whether that thing that it exists in abstract terms then also exists and delivers in practice. So we might have diverging perspectives on the level of the definition as well as on the level of the application of that definition in practice, and biases between old and new member states, as you indicated, might be playing out and making our life even more difficult. So Katja Triller-Vertowicz, what would you make of the arguments that we've heard, and would you say that those arguments are strong enough to justify, for example, the Hungarian and the Polish perspective that what they're doing is also the rule of law, but in a different way, and maybe for other good reasons that need to be done in order to put their house in order? So how do you see this problem?
Yes, hello, Matej, and thank you for inviting me to be part of your academic forum. This question of yours, I will save that for the second round of the debate, because first I want to focus on the definition of how I see the concept of rule of law. And I agree with my previous speakers, but I would like to emphasize the difference in the perspective of what the rule of law is if you're looking from a lawyer perspective or from a politician perspective. Because traditionally speaking, when we went to law school, we were taught that rule of law is like a very broad legal concept that includes a system of how a corpus of legal rules should be built, ideally in theory, and as well as a system of how an individual can correct one of these elements if they do not work in practice. So, for instance, like Venice Commission has said, the legal rules must be certain and foreseeable, and they should treat all individuals with dignity, equality, and rationality. And also, an individual should have the possibility to challenge these decisions before independent and impartial courts in fair proceedings. That was like a traditional notion that everybody agrees upon. But what I saw in the last years is more a progressive approach that was being used by the politics, and this traditional concept was expanded, and it does not include not only a system of checks and balances between different branches of sovereign national government, and in relation to one individual, but also it extended to free media and conflicts of interest between the government and economy, or between one government and the other government. And on the part of the sanctions, it not only includes a system of legal remedies, but it also includes a system of how can other governments from other states, that is from the outside, can correct these elements if they see that they don't work in practice. For instance, they can withdraw EU budget funds, or they can withdraw voting rights from such a member state. Since both of these concepts include, as well as mechanisms of how things should look like in theory and how we should fix them in practice if they don't work, I think these concepts are both self-repairing. So therefore, I don't see there is a rule of law crisis. I would rather talk about rule of law renaissance, because the concept is expanding not only to legal remedies and to legal areas, for instance, the traditional checks and balances, but also to non-legal remedies. And so I don't think there is a rule of law crisis if we are looking from the perspective of the concept itself.
Excellent. That's a very good point. So rather than crisis, we're looking at the renaissance. Renaissance, probably Armen would agree with me, of the concept, of the interest into the concept. But what about practices? What about practices? Because Armen, you announced, as we chatted at the beginning, that you will sort of shed a comparative light on the phenomenon of the rule of law. And maybe just to stick for a second with what Katja has said about the renaissance of the concept, I wonder how much this renaissance of the concept helps us, or helps actual people on the ground, if we stick to the idea of Martin Krieger, who has argued that the essence of the rule of law is the prevention of arbitrariness. So if on the one hand side we have a great renaissance of the concept and a lot of talk and a lot of ado about the rule of law, which makes things murkier than they used to be, at least to my mind. On the other hand, there seems to be more arbitrariness, especially in some member states. But Armen, how do you see this situation? Also from your uniquely placed in Armenia, a country that myself and my students do not know much about. So I think you're bringing an extremely valuable comparative input by your own professional uprising already in this debate. So please, what do you make of this debate so far? And just unmute. Okay.
Yes, thank you very much, Mate, and thank you for the invitation. It's a very thought-provoking debate, which I'm very happy to be part of. Actually, I'll try to do what I promised and what you just asked me to do a comparative perspective, also a little bit of a theoretical or historical perspective. And also echoing, especially Katja, the previous speaker, with a thought-provoking thought about the idea about the renaissance of the concept, but probably from a different perspective. I would say it's a little bit of exaggeration of the concept or misunderstanding of this concept that we see currently in this particular context of the crisis in the EU. But I have to go step by step, and I will simply start with us trying to answer your first question, which is the title of the discussion. I think there definitely may be different perceptions of the concepts of the rule of law. Perceptions, I stress. But there should be only one plausible concept of it if we're speaking about its application in the community of sovereign free members such as the EU, which has a set of elaborate conditions for membership and a highly sophisticated normative framework. And now, if just to taking the momentum for being provocative, I think that that's a good thing for academics to be a little bit provocative in a reasonable level, actually. Let me suggest that the concept of the rule of law is derivative. Something that we're probably underestimating sometimes. This concept, it depends, it derives from the statement of the law, the main conditions. So if we're speaking about the two elements, the two pillars in this concept, rule of law. I think the main issue in our problem is about the conditions, is about the law, and by and large, which implies their implementation. The element of the rule implies the implementation. In the context of the EU rule of law crisis, I think the concept is often misplaced. And I think the main issue in the crisis is not about the rule. It's not about implementation. It's about the conditions. Let me approach this perspective, but step by step. But I'll do my best to be as quick as possible. My first point is that rule of law is unconditionally a concept of political liberalism. There can be no rule of law in Iran. I'm speaking about Iran because there are some rankings, some, by the way, some very highly respected political regime rankings, which, for example, would speak about a very sophisticated state of rule of law, literally, in countries such as Iran. There may be a very sophisticated level of application of the law or legality in Iran, but the rule of law concept is inapplicable to Iran or countries which are not belonging to the liberal world. By definition, this is a concept of political liberalism. The pillar of law in the expression is not merely about any regulation or rule. In Iran, we may have a lot of regulations or rules, some kind of a higher law of their own kind. But the concept of rule of law implies a set of higher laws of a very definitive nature. It's a set of higher laws which are not subject to the discretion of the sovereign, which belong to the Western liberal world. The rule of law is not also only merely about enforcement. It implies equal treatment and concern. This is probably the key in the core of the definition of rule of law. I'll look at the evolution of the concept from the antique times, basically, starting from Aristotle, probably. As a concept of political liberalism, rule of law implies the framework for abiding by the conditions for cohabitation. By the way, I came to this definition right preparing for this discussion. I don't know if I would be happy to hear what you think about it, but I'm very happy about it. The framework for abiding by the conditions for cohabitation or cooperation among the free sovereign members of a political community. I would stress many pillars of this definition, but probably my time doesn't allow for that. In a community of free members, and I stress the free members here, unlike in a different other society, members participate in making of laws which will guide their actions. If we take the European Union, they participate in lawmaking. Take the founding members or those who were literally participating in making of the treaties, or at least consent to it. And here we can speak about those members who were joining later, acceding to a pre-existing treaties. So either you make the treaty yourself, either you make the law yourself, or at least you consent to it. Unfortunately, this is a privilege which is given only to the free world. I mean, throughout the history, law has mostly been imposed on the people or on the nations rather than the contrary. I mean, it was imposed by the rulers, the power holders, the tsars, the kings, the feudals, the colonial empires. By the way, if we do the comparative analysis, the perception of law in those societies and in the perception of law in societies which have evolved through self-determination is quite different. And I have done a lot of research myself on the topic and have written of legalism. And if you see where the formalistic interpretation of law is more prevalent, then you could probably go to the recent post-colonial world, where the people are not used to actually being part of the lawmaking and being part of contesting the law. The law is given to them as an instruction, as a non-order. This is their instincts, which are also persisting through time. As a matter of principle, not any law enacted in a community of free members is the narrow self-interest of the individual members. The logic of cooperation among the members requires that each individual self-interest of a member has to be sacrificed for achieving the big collective interest. And this is very much applicable to the European Union. So if we go straight to the implications of what I'm saying to the EU and the crisis, let me tell you that EU is the highest and the most sophisticated form of liberal community known to me. It's a community of free sovereign members which have joined the club on their own initiative. they are part of the lawmaking, and no one had made them to abide the law. It is their own will. Again, it's a club of sovereign and free members. This community is guided by a set of higher norms. And I may refer to Article 2 of the Treaty of the European Union. Now, the issue behind the crisis, as I understand it, is not about implementation that much. Of course, the default deviation in the crisis is about implementation, but the core of it is about the conditions. But I make this distinction not solely for the taxological purposes. I think this makes abidance by this even more imperative. If the conditions of the cooperation, the law, are contested, and I think these are still about the conditions and not about implementation. The attack on the media in Hungary or the attack on the judiciary in Poland, they may be said they are problems of the rule of law, but they're more likely problems of the definition of what is democracy. So if I would go back to Article 2 of the Treaty of the European Union, I would probably not simply separate the issue among the rule of law issue and democracy or human rights issue. I think these are one context. And simply those countries are not meeting the conditions. But again, I'm not saying this just for aesthetical purposes. As lawyers, we understand one thing. If the conditions are not clear, in a legal system, this cannot be a reason for not abiding them. At the end of the day, any legal system, and that of the EU is not an exception, have the instruments for making these conditions clear through interpretation, case law, and ultimately dialogue. If what we perceive as a default in Hungary or Poland is perceived there locally that it is not, then there have to be some instruments in the legal system which should provide the ultimate answer. So references to a pluralism of rules of law sound implausible to me in this context. It's simply, if the conditions are in default, then the conditions should be made clear. Let it be by the European Court of Justice, let it be by any supranational instrument, but then implementation is imperative. There should be no default in implementation. There should be no default in rule of law. Rule of law has to define the law, and then it has to be implemented. I stop here.
Thank you very much. Thank you very much, Armen. And I think this really opens the door for continuing this debate with the second round of questions, because I think, and referring back to what Antonia has said, when you, Antonia, mentioned the ruling of the Court of Justice of the European Union on the famous conditionality regulation, there the Court of Justice of the European Union, to use Armen's words, made those conditions clear. So the conditions, what the rule of law actually is, what the standards, what the benchmark standards are against which the practices should be measured, this seems to be clear. And I think not just seems to be clear, this is clear. It's been decided by the force of the law by the Court of Justice of the European Union. And as Katja Tillervertovec has also indicated, this has been part and parcel of the broader understanding within the environment of the European constitutional law, and echoes through the standards of the Venice Commission. So if the conditions, for the sake of the argument, to move on a little bit, right, are clear, so there can be no meaningful relativism, I wouldn't use the word pluralism here, but really relativism about the conditions. Relativisms, stemming from the variety of pluralities that one might come up with. If the conditions are clear, then when the implementation doesn't deliver, when the member state which is under scrutiny doesn't deliver, what to do about it? And maybe, Antonia, here is the right moment to invite you back. You have recently, as I already mentioned, you authored a book on this topic, but you also wrote, you published a very fine article with the German Law Journal on tackling the problems of the problematic states, as it were. So what to do when the member states don't comply?
Yes, thank you. So I just want to add a brief point to the previous round. So because, and I would like to bring my contribution as comparative constitutional scholar. So we are talking about rule of law crisis in these member states, but we cannot forget that this is also a constitutional crisis inside these member states. So we see, of course, a rule of law crisis, but also a democratic backsliding. And these two phenomena are different but intertwined. So I would like to also to raise this point. Of course, when we look at the role of the European Union, we look at the rule of law side of this crisis, because the European Union cannot intervene in the domestic sort of crisis, so in the constitutional crisis, but these countries are experiencing a double-side crisis. So with regard to the European Union, so we all know that so the rule of law, so-called rule of law crisis in Hungary and Poland is not new. So these are crises that are ongoing since 2010, 2015, with regard to respectively to Hungary and Poland. And so the European Union has tried to deal with these crises. And in the end, we saw that Article 7 has not been effective, also because we saw the limit of the legal rules vis-a-vis the political side of this kind of relation, the political bargaining that has a lot of weight in this kind of relations. Also because of this vague concept of the rule of law. So the European Union must be very careful in intervene where the European Union has competence into intervening, not stepping into the domestic sphere. So the European Union is inherently limited also to tackle this kind of crisis. So we saw the failure, we can say, of the Article 7 procedure. We saw several mechanisms of so-called soft law, dialogical mechanism that has been implemented vis-a-vis all the member states. So the rule of law reports that tackle the possible rule of law crisis or inconsistencies in all the member states. And finally, this conditionality mechanism, which seems to be so far the most effective tools to at least exercise a kind of influence, pressure against these countries. But I would like to underline also this aspect of the regulation, because the regulation is a regulation which tackles the damages that rule of law violation can bring to the budget of the European Union. So it is not straightforward a mechanism to tackle rule of law crisis. Is a mechanism that is aimed to protect the European budget when it is affected by the rule of law crisis. And so this is a key point of the regulation, because otherwise the European Union cannot have the competencies in dealing with directly the rule of law crisis in a member state. So its action is based on protection of the European budget. And the other things that is key to this regulation is that so there is the European Union, the Commission must demonstrate that there is a direct link between the so the damage with the European budget and the rule of law crisis. So it is a proof that the European Union must bring in order to activate this mechanism. So this mechanism is inherently limited, but this is I think the reason of its effectiveness. So it is effective because it is very precise and can be applied in a very clear way. And it is what happened with regard to Hungary. We saw that this mechanism has been activated vis-a-vis Hungary, and its activation has been confirmed by the Council recently. So at this moment, we have this prospective suspension of a part of the structural fund. The case of Poland is different because different is the rule of law crisis in Poland, which is very much focused on the judiciary. So it's inherently different than the Hungarian case, which is more focused on corruption. So something that can be clearly bring as a direct link with the management of funds and corruption. The independence of the judiciary is, in my view, a case, is a very hard case to demonstrate this direct link. And also we cannot forget the political consideration with regard to the role of Poland vis-a-vis the war and the Russian position. And so we also see how, again, politics matter also in the activation of illegal tools, which is the rule of law conditionality mechanism. So I stop here and maybe we can talk later.
Very good. It's a lot of interesting thoughts that you put on the table. There's a lot on our plate. I will take this plate to Katja Triller-Vertovec now. And Antonio, you mentioned that you know, you're not the only one who's made that. I mean, you described correctly what this conditionality regulation is actually about its effectiveness, about its limitedness, being narrowly tailored to tackle the negative effects that impair the budget of the European Union. For many, that would be, and it has been too little in terms of the rule of law protection. For others, it has been too much, right? And it has been, again, overly vague and leaving too much room for a political discretion, especially to the body of the European Union, to its executive branch, as it were, the European Commission. And you painted that picture a little bit when referring to Poland, that special circumstances that surround that case. Katja Triller-Vertovec, I know that you've studied that regulation really well. You had to study it when you were still in the cabinet of the Prime Minister in the previous government during those hard negotiations. So how do you see this regulation today, when it's first been put into action, in comparison to the time when this regulation was coming into existence?
Yes, definitely. I studied this conditionality regulation from A to Z. If I compare this conditionality regulation to other mechanisms that could protect or tackle the rule of law, I see three mechanisms that, if I compare them to different knives, if somebody wants to use to cut out the sick or the disease out of one's body, like if we say that the corpus juris is like a body, like an organism, then there is one mechanism that looks like a butcher's axe. There is another mechanism that looks like a chef's knife, and the third mechanism that looks like a surgeon's scalpel. For example, this Article 7, I see it like a butcher's axe, or some people say it's like an atomic bomb. Everybody has it at home, but they're not supposed to use it, because this would cause too much bleeding to the European Union, which is even politically now not very wise because of Russia, and we have to stick together in this time of this global situation. If I answer to is this effective, I don't think this mechanism is effective because there are always several bad guys in the classroom that stick together, and they stood up against the head teacher that wants to implement this rule. But on the other hand, this Article 7 is certainly legitimate because it's based in the treaties and there is a separate decision required, one for establishing there is a breach of law. There must be a separate vote in the council, and there must be another decision establishing a proportionate sanction for this. This Article 7 mechanism is also democratic because the decision on the breach must be decided by the European Council by anonymous vote. So that's also the cause of the inefficiency. But then we have a conditionality regulation, and anecdotically I compare this to a chef's knife. And not, I mean this like a mechanism used that can be used by an angry chef in the kitchen against one of his cooks that he's complaining about. And this is the major shift in the concept of the rule of law, because the traditionally the mechanism an individual had against a system of government that breached his rules was more like when there was an unsatisfied customer complaining to the waiter that there is hair in his soup. So nothing could be done about it, or at least very little. But now this conditionality regulation has become a weapon of a chef that's in a superior position against a chef of one of the states. So this is used from the position of power against the weaker enemy. So this is really, if we look from the efficiency side, this really is a much more efficient mechanism to use. But it is also efficient procedurally, because this conditionality regulation requires no separate finding of a breach of the rule of law, only deals about the proper sanction by the council. So it's a kind of contradictory that the most efficient tool that achieves the result that wasn't intended in the first place. Because like Antonia has said, the purpose of this rule of law, of this conditionality regulation, is not to penalize breaches of the principles of the rule of law that was said by the European Court of Justice, but it is intended to protect the union budget. So the conditionality regulation is not even intended to protect an individual against the state. It's intended to protect an institution itself. So I think that is really, I can't even imagine the shift in this. It's a paradoxal to me. And I also have a question if this conditionality mechanism is legitimate. Because the question whether there was a breach of the rule of law in one country is not investigated by independent and impartial court, in this case the European Court of Justice, but it's only a finding, a factual finding of the Commission that was notified to the member state. It's not even a separate decision. And thirdly, it's also questionable whether or not this conditionality mechanism is democratic, but because the value that is protected by this mechanism is are not individuals themselves, but the union budget per se. So that's why I think it would be the safest from the constitutional, or from the perspective of constitutional lawyers, just to stick with the third mechanism, and that's in the form of the surgeon's scalpel, and that is this financial regulation that was put in place in 2018. With the similar aim as this conditionality mechanism, that is to protect the budget of the EU, and this mechanism ensures that the EU funds are not misused by any tax havens, and that there are audits and increased transparency. And I think this mechanism is as well as efficient, as well as legitimate, and as well as democratic. So I would prefer to stick with the traditional mechanisms.
Thank you. So a lot of, you see, I mean, from the rule of law renaissance, what we arrive at are a lot of axes, knives, and scalpels. But problems still do persist, and I would like there are different directions that the debate could travel now, but I would go back to or continue rather with Katja Retz-Longer, and to pick up a point which or a mechanism that doesn't qualify neither as an axe nor as a knife, let alone as a scalpel, but also something that Antonio referred to as a soft law mechanism. And you revealed to me prior to today's roundtable discussion that just now the European Commission is engaging with the member states in order to obtain the data that are relevant for preparing the national rule of law reports. So I'm wondering, and we all know that those rule of law reports have come about as a sort of a preparatory phase that was meant to avoid the kind of a nuclear phase in which we are now. So I wonder, Katja, on the basis of your experience, how have you found that interaction with the European Commission, and how would you judge the utility of this soft law tool?
Yeah, I mean, I have to say that it's very useful actually, because we have we have this criteria, we have detailed questions, we have regular discussions, and I think it's very useful from the point of view that you have an overview of the systems in all member states. And so, of course, sometimes these systems are not comparable, but I think this dialogue is very important. And I would absolutely agree with Armen. This is a crisis of democracy as well. And I mean, if I was not clear before, I mean, absolutely, we cannot say that Poland and Hungary function at the moment as democratic states. And this is where I think that it's very useful to have this overview. It's very useful to have court judgments, like you said, Matej. I mean, this is where the definition is very concrete. It gets very concrete. What I have been noticing from my practice now, with the involvement of the jurisprudence of the court, is that mutual trust has been sort of disintegrating as a consequence of the rule of law judgments. For example, mutual recognition mechanisms, which are really based on mutual trust. This is an essence of cooperation among member states in justice. We have been, I mean, the steps have been taken. We're going back to MLA, to mutual legal assistance, where we can have more grounds of refusal. And this is just, it affects just, it's the rule of law mechanism. Yes, of course, it's very useful and it shows that the real picture, but the real picture is that we are cooperating less with each other in justice, which again, generates a bit of a rule of law crisis, because if we don't cooperate smoothly in for example, in the field of criminal law, people don't get justice, basically. And this is what worries me. But you know, it's not only the European Union. If you see what's happened in the capital and in the States, what's going on now in Brazil, what we're, you know, always, my feeling is that we're always addressing symptoms when we're discussing the rule of law, because we should be asking ourselves, why are we here at the moment? What happened? I mean, it's my theory, and that it's the aftermath of the financial crisis, and that basically all answers are in the economy and not in law. Okay, as lawyers, we need to discuss certain things, but I think that the solution is outside of law and in the economy and in the system, basically. But this is my, I mean, just theory, very not professional. So I'm not an economist. That's what I wanted to say. So basically, the bottom line is, yes, it's very useful. We have an overview, but we need to see where to go from this. And I tend to basically agree with the conditionality mechanism, because I think the underlining sort of philosophy is that we do not want to fund member states that are not democratic, and it was absolutely effective with Hungary. So I don't see. Yes, of course there are some issues to discuss maybe, but I think that it's quite a legitimate answer to this problem. So thanks.
Thank you, Katja. Very interesting. Again, a number of points that we could pick up. Maybe Armen, if you want to, in a way, it was your intervention that spurred this debate. Would you like to react to it before I pose a question to you?
Excuse me, Mate. React to what?
To what your predecessors have said, especially because it was you who insisted, saying, well, once the conditions are straight, what matters is implementation. And do you think that the implementation has so far, you know, worked, or and we know that it hasn't, but the question was and remains whether the mechanisms that have been devised, are they good enough, proportionate to remedy the situation on the ground, provided that we stay limited just to the legal state of affairs? Because I agree with Katja that the problems stem from from much more below, from the other subsystems of our polities. But in terms of enforcing the standards, the conditions that are now clear, do you think this is everything that? Do you think that the mechanisms that are at our disposal are sufficient, or could you envision something else, Armen?
Yes, thank you, Mate. Least of all, I was prepared to speak about the efficiency of the mechanism in the European Union, being myself someone who is an outsider to the European Union. I think this is very much an issue that you guys have to decide domestically in the European Union. And I may only, as let me call someone who attempts to speak about theory, which is transnational, I can provide one or two perspectives simply. Again, my point was that non-implementation is simply unacceptable. If the rule is clear, and if everyone tells you this is the rule, but you do not abide by it, then not abiding is not acceptable in a community like the European Union, which is voluntary and which is based on free membership and collective action. This is simply not acceptable. What is acceptable, and I would even say it's even very much desirable in a democratic society, is that there has to be, and there is a debate about the conditions for what the rules are. Actually, here we speak about constitutional pluralism rather than the pluralism of the rules of laws, which is actually a concept which doesn't make much sense to me. What this current countries which are in crisis or which are causing the crisis. I'm saying the current because the crisis hasn't been hasn't come to the European Union only with them. There have been some predecessor crisis, also probably not this scale. And I'm afraid to say that probably there may be some crisis coming later. What this current entities which cause the crisis purport to say is that the issue is not about implementation, it's about the conditions, and then we debate the conditions. We want to have a sound discussion about it. This is legitimate if we believe in what they're saying. Myself, I'm not very convinced that this is the case. At least in one case of Hungary, I'm very much convinced that this is a pure manipulation. This is a power holding and quite much a quasi-autocratic project, which is simply manipulating the public opinion and the EU rules in order to reach its own ends. And yet, since the question is very much political, then I think regardless of the red lines that should be there in order to recall any instruments which are extreme and which are actually recalling what my colleagues just mentioned, including Article 7 of the Treaty of the European Union. Regardless of all these measures, I think dialogue is the only answer that, or the only viable answer that can exist among peers, equal peers, colleagues, and those who are members of the European Union. Again, until the point reached the red lines, which surely signals that this is a condition that doesn't actually have to be tolerated anymore. Again, as someone from outside the European Union, my impression has always been that since those red flags haven't been raised so far, probably the political dialogue in one way or the other is ongoing, or there is a hope that it will be ongoing, or that the situation will be resolved through political means. This political means may be the next elections. In Hungary, we see that all the next elections end up in the same result. But for Poland, we're expecting the new elections right this year in 2023 in the fall, as much as I understand. But again, if your peer is in default, then political dialogue is probably the instrument to be recalled unless it really crosses the red lines. And then
okay,
I leave it up to you if you think that the red lines have been crossed or not.
It's a very sort of self-restrained intervention. But let me, since we are now basically entering the final round, let me continue debating this a little bit with you. You refer to constitutional pluralism, a concept that you know it's very close to my heart. And its essence has always been that, you know, the European Union functions in a hierarchical, horizontal rather than hierarchical, top-down imposed manner, and that its essence is mutual trust, sincere cooperation, that due to the defaults in the very observation of the rule of law is now pretty much dwindling, as Katja Retzlonger has described. And you have, and of course, the gist of the constitutional pluralism has precisely been a dialogue, judicial dialogue and political dialogue. But I wonder to how far this dialogue can be actually, how far it can be taken. And it's not just about raising the red flags. It's something more, something that you mentioned at the beginning of your first intervention, or in the middle of your first intervention, when you said that the rule of law is a principle which is which cannot be separated from a broader context, from a broader idea of political liberalism. But, and you were referring to that we have a politically manipulative regime in Hungary, but I would say even more, not just a politically manipulative regime in Hungary. What we have in Hungary, it's a regime that would like to play a different game. They declare that they aren't any longer playing a political liberalism, but they opted for political illiberalism. So what to do with that? Because if we can we have inside the European Union a constitutionally pluralist structure in which 26 or 25 member states partake of the project of political liberalism, and one or two decide that they would be part of this club, enjoy its benefits, including the increasing budget, and yet turn their society into politically illiberal regimes. What do we do with that? Armen.
Mate, yes, there are sometimes questions which cannot be answered straightforward. Let me try to be provocative again. I think when exactly among so many members, we only have one or two, which are the bad guys in the club, it's rather good news than bad, because it means that the vast majority of the countries are on the right track. Do we have to have bad guys at all, or do we need to eliminate them at all levels? Again, there have to be red flags, but to what extent should we tolerate the bad guys? I mean, one thing that I would like really to warn everyone, including those in the European Union, and this is from my rather global perspective, is avoiding any tendency that may lead us to ideological totalitarianism. Because yes, they are the bad guys. I don't like them myself. I think there is the vast condemnation of them in the European Union too. But then one thing that is very important is to keep at least a reasonable level of debate and deviation within even the ideological spectrum. Otherwise, the tendency to ideological I don't find the term, I don't find the word, but something that is based on really a very single perception of anything, democracy, rule of law, is another extreme that may, in a long run, make us simply deviate from the basic tenets of democracy, that is pluralism and dialogue. So far having those deviations, so far having those cases of default is basically the reason that makes us to look at the issues from the critical perspective.
Okay, thank you. Very, very interesting. So I think the word would be just imposing, turning in Rawlsian words, this would, if we follow the logic of the argument that everyone has to be a liberal nowadays, we would turn political liberalism into its own comprehensive doctrine, and then in that sense makes basically defeating the very idea of political liberalism to begin with. But that's a theoretical debate, something that would be very interesting to explore, but unfortunately we don't have time. But I would like to continue with Antonia and your study of different federal regimes and the lack of compliance, as it were, even significant lack of compliance, as it were, from the federated regimes within a federal entity. And I wonder, do you think, having studied the US, having studied Canada, do you think that once this kind of federal committee, such as, mutual trust, sincere cooperation breaks down, does that actually call for federating the polity, for imposing even more top-down the overall federal yoke? Meaning, in European terms, in terms of the European Union, that this kind of a disobedience on behalf of certain member states would lead to a more stringent insistence on supremacy of the union's role and imposing from the top down, from Brussels to the capitals of the member states, the European standards.
This is a very interesting question, and So I don't have a straightforward answer to this question, but I may bring some hints from the comparison with the US, but also with Canada, because what we see in Canada is this fragile equilibrium between the federation and the provincial claims for autonomy, in particular Quebec. And what we have seen is that the Canadian Federation is built upon this mutual recognition of course, the federal power, but also the respect of the autonomy, of the peculiarities of some provinces, especially like Quebec, but not only Quebec. So I think that, yes, probably these moments in which we see more closely the tension between competing legal orders, of course, they may strengthen the endurance also of a federal or quasi-federal project, because they highlight the tension, and also they allow us to achieve a kind of equilibrium of different competing legal spheres. And this is what happened in Canada, for example. So in Canada now, the federation is well aware that it cannot step into the provincial autonomy, and they have so maintain this kind of equilibrium. Maybe it's fragile, it can be subverted in the future, but at the moment it functions. And so what I see is that, so we also need to look at the European Union not only with the lens of the rule of law crisis, but also with the other challenges that the European Union is facing. So if we look at the next generation EU, we see a different story. We can tell a different story of the European integration process. So I think we should look at the relationship between the EU and the member state in a comprehensive way. So not only focusing on what is broken, the rule of law crisis, but what is also positive. So the step that we saw with, for example, the next generation EU, in which we saw a different application of conditionalities, for example.
You're absolutely correct by indicating into the need for comprehensiveness, but if we were too comprehensive today, we would absolutely run out of time. But thank you for bringing this point into our debate as well. I mean, it's focusing on the crisis, on the problematic. Of course, very many times the other more positive sides, the brighter side of the moon, just sort of eclipses. It's not in the forefront. Katja Trille-Vertovec, I would like to continue with you, and there has been a question from the audience, from our student, who agrees with you actually. So I have to use this question, and he's saying that that maybe the gist of the problem in the European Union is that we are trying to solve the political issue of the rule of law in a legal way with a political approach. And he suggests, I mean, in a way echoing what you have said, that rather than the regulation as such might not be the answer, but that we should be rather more focusing on the values, on the underlying values of the European integration and doing things differently there. So how would you respond to that question?
Yes, thank you for the question. I agree with the question that it's probably this regulation is a mixture between politics and the law. And I would like also to refer to Antonia, which said that we should have a positive approach on the thing. And actually, I do think that we lawyers, we see a rule of law as an ideal. So we see it it is like a constructive term built of many different elements, and this is an optimistic approach. But in the late years, politicians turned this upside down, and they don't see a rule of law as a common denominator for many different elements, but they describe it in a more destructive way. They say when one element is endangered, then the whole rule of law is breached. For instance, if an independence of judiciary is endangered, then the rule of law is breached. If the media freedom is jeopardized, then the whole rule of law is breached. And this is a very pessimistic approach, which I don't agree with. I agree that and the problem is that this regulation from the political perspective is actually very efficient for one member state or for the European institutions to get leverage on the one disobedient member state. But the problem, in my view, is that it is contradictory. That's what I mentioned. Its aim is not to protect the individual, but its aim is to protect the European budget. And it's also confusing because I cannot quite understand what the ECJ meant when they said that even though the EU respects the national identities and the political and constitutional structures, in no way follows that obligation as to the result to be achieved may vary from one member state to another. So let me now get back to the houses you mentioned at the beginning, Matej. Well, if this building a rule of law is like building a perfect house out of different national elements one has at his disposal. For instance, in Alaska, they built igloos, or in Canada, in Africa, they have straw houses, in the desert, they have tents, and in Europe, we have brick houses. So if we are we allowed to build our own house out of our own elements, or are we only allowed to have brick houses? So what does that mean to have the unified result with the different elements? I find that confusing. So I'm not sure if that can be resolved. So I pass the ball to you. Maybe you have an answer.
No, I don't, and luckily I'm the one who's posing questions today. So next time maybe. No, but even if I think it's an interesting point, and if we had more time, we could go into it because it refers us back to where we started. That is basically addressing the very conditions of the houses, bricks, straws, and so on and so forth in terms of the very definition of the rule of law. But maybe to draw on that, I'd like to conclude with Katere Longar, who started her intervention today with the remark that the rule of law is evolving. So we heard a lot of things about the rule of law today, that it is indeterminate, that it is in crisis, it's not actually in crisis, that is being exaggerated, that is in a renaissance. But you have said that it is evolving, and that what you're doing today, 10 years ago, this couldn't even be, you didn't say that with your own words, but I will say it, couldn't be even imagined. So what did you mean by that?
Yes, thank you for that question. It's very interesting. Yeah, I mean, I'm the crises have been shaping, I think, the concept of the rule of law. I mean, for example, in COVID crisis, there was this disbalance in checks and balances in favor of governments, for example, because of the emergency measures and stuff like that. And now in the context of, for example, of Russian aggression on Ukraine, which is absolutely abominable, and let's not go into this. I'm not justifying anything, just as a disclaimer. However, we are trying to, in the field of criminal law, we're trying to solve sometimes issues with criminal law which are not solvable by criminal law, unless we want to lower the standards. And what I meant with that was, like here now we have these ideas on how to, I have to go back. We can confiscate or freeze assets via two avenues. One is the CFSP. This is the sanctions mechanism, which is political mechanism, and these assets are frozen in an administrative procedure, for example, and they cannot be, at least for now, they could. There was never an idea that they could be confiscated permanently. And then, of course, we have the criminal law confiscation, which is linked to a crime and stuff like that. So now, for example, we have these ideas that we should permanently take assets which are frozen in administrative procedures via administrative tools, which are basically sought by governments. And this is such a dangerous concept for me, because what about right to property? How are we going to justify this? Because if we lower our standards in this respect, in this case, then probably we'll have to apply it in all cases. It's not just Russia that is at the moment being sanctioned. And this is where this is only one example, but this is where these dangerous examples due to a crisis come in, and these concepts unfortunately stay. It was the same with terrorism, for example. Certain concepts stayed. Okay, so certain were overturned by the courts, thank God, but certain concepts stayed, and we're getting into this law and order system, which is sort of problematic, which would be problematic if we're seeing it with the lens of, I don't know, from the 90s, for example, before all these crises started. And this was my point, that we should be careful that even in the crisis, we do not give in to emotions, that certain things are absolute, they are not relative. Certain values are absolute. And this is where I think that we cannot say that we cannot sort of not admit that certain member states have problems. I don't think it's only about building different types of houses. I mean, it would be really, I don't know, dishonest to say that we don't see a problem in certain member states and we need to address them. Yes, there are certain avenues how to do it. They're different, but still. My last point would be that how about the rule of law at the European level? For example, Qatargate revealed many problems, including, Matej, our favorite, immunities, for example, because the European Union is basically this hybrid between somewhere from federation, and there are certain very strong elements of international organizations which are basically a bit hindering the rule of law and checks and balances and stuff like that. So this is maybe one area that should be further explored, maybe in the future.
Thank you very much, Katja, for your last intervention, and of course making this debate even more interesting and harder indeed. We have heard several times from your side that you do not have, from the side of all of you, that you do not have a definite answer, which is absolutely normal, because we have really tackled a very hard conceptual issues that are indeed evolving through across practices and across time, facing different challenges. What I think is important and of quintessential importance is to stick with this idea that not maybe necessarily that the rule of law is some sort of an absolute value, but that there is indeed the core overlapping consensus what the rule of law has been. And if not that, at least that there is still an overlapping consensus of what we get if we do not stick to those core values of the rule of law. We really get sheer arbitrariness that can just grow in its degree. For that reason, I believe, and this is my own normative input, that despite the provocative question that this panel was dedicated to, if whether there is a plurality of rules of laws in the European Union, myself, I do believe that there is no such thing as a plurality of rules of laws. I think that there is a very there is quite a clear understanding of what the rule of law is and what requires and what it entails, and it does so, as Armen has pointed out, on certain prerogatives, on certain predicaments of a particular political liberal constitutional order. And the European Union has been built in that image, and those have been the rules of the club that I think have to be enforced. They have to be enforced, as you have indicated, internally in the member states, on the supranational level, against also the institutions of the European Union. And therefore, it's very important, as Antonia has mentioned, that when devising the mechanisms to protect the rule of law, that those mechanisms are also devised in line with the requirements of the rule of law and applied in line with the requirements of the rule of law. And then finally, also the application and the abidance to the rule of law in external relationships of the European Union, even when dealing with countries that have absolutely defaulted in that regard and are exercising a major aggression against one of the sovereign states in Europe. So there is no conclusion to the debate about the pluralism and the many faces of the rule of law. The only conclusion is that we have unfortunately run out of time, and this means that I have to thank you, to the participants, to the speakers today, for your great interventions. As I've indicated during our talk, the discussion could have veered really in different directions because you yourself have different backgrounds, different professional experiences, different points of views, and even in this basket of differences, it is important to stress again to have an overlapping consensus of what really matters in the society, so that we live in an ordered plurality in a non-arbitrary world among, as Armen has pointed out, in the European Union, which is one of the most sophisticated political liberal regimes where sovereign member states cooperate in peace for many, many years. And I think that's a great achievement of the European Union that we should be proud of. But at the same time, we have to take care of the fact that this doesn't get dismantled for a variety of short-term political gains. I thank you again for having taken your time this afternoon, and I hope to see you soon in person in the near future. Take care. Bye bye.
Thank you.